Assalamualaikum warahmatullahi wabarakatuh and very good morning to distinguished guests. My name is Sofiah binti Muhammad Sofa, a PhD student at University Kebangsaan Malaysia. Today it is my privilege to present to you my article titled Evaluating Monitoring and Compliance in Deferred Prosecution Agreements, Safeguarding Accountability and Integrity. Before I proceed further, it would be better if I explain what a Deferred Prosecution Agreement (DPA) is. DPA is a mechanism used by the prosecutor for resolving corporate misconduct, allowing the alleged company to avoid a criminal trial if they refrain from further wrongdoing, subject to the terms agreed between the prosecutor and the alleged company. Among the salient terms of the DPAs are monitoring and compliance, ensuring that the alleged company is fulfilling its obligations and taking steps to remedy the criminal misconduct that led to the DPA. Among common law countries that implement Deferred Prosecution Agreements (DPA) include the United States, where the US is the pioneer in the use of DPAs and has extensively used DPAs, particularly by the Department of Justice to resolve corporate and financial crimes. In the UK, DPAs were introduced under the Crime and Courts Act 2013. They are used to address corporate crimes such as bribery and fraud, with oversight by the Serious Fraud Office. While in Canada, the DPAs were introduced through the Remediation Agreement regime in 2018 under its criminal code. Last but not least, in Singapore, DPAs were established through the Criminal Justice Reform Act 2018, providing prosecutors with flexibility in addressing corporate misconduct. Well, to improve internal compliance processes, companies must change their structure and culture, implement monitoring, and implement accountability and reparations. In the US, a monitor evaluates and oversees a company's compliance with DPAs to reduce the likelihood of recidivism of wrongdoing. Companies may not require a monitor if they have stopped operating due to corporate misconduct. If necessary, they implement compliance procedures such as hiring external auditors and conducting internal ethical training. In the UK, corporate wrongdoing is monitored through a compliance program, with the DPA requiring accused companies to establish or amend their compliance program. Companies have placed more emphasis on compliance to reduce regulatory violations and damage to their finances and reputation. The effectiveness of a company's compliance program must be thoroughly examined, reasonable, regularly evaluated, and tested. Businesses are often forced to invest more in compliance measures, usually with the supervision of an outside monitor, rather than go to trial. The government and the business will recommend a list of possible applicants for the position of independent monitor. The DOJ has mandated monitorships in the US as a requirement for settlement agreements with corporations in at least 44 cases. Almost all of these agreements date from 2003 or later. The Moffat Memorandum, released in March 2008 by former Deputy Attorney General Craig S. Moffat, provided the initial official instruction for US prosecutors about the use of independent monitors. The said memorandum was issued due to the notable suspicion about the large fees charged and suspected cronyism between monitors and prosecutors in the US. As aforementioned, each case's unique facts and circumstances will determine if monitoring is necessary. Therefore, prosecutors are instructed to execute a cost-benefit analysis to decide whether a monitor provision needs to be inserted as a term in a DPA. The designated prosecutors must take into account the benefit of the monitorship for the corporation and also the public. Among the principles in the Moffat Memorandum include the need for a thorough discussion between the government or prosecutor, the company and the monitor, adhering to conflict of interest guidelines, forming a committee to decide potential monitors, ensuring approval from the Deputy Attorney General, and avoiding endorsement if the government or prosecutor has a relationship with the company. The monitor must be an impartial third party overseeing internal controls, corporate ethics, and compliance programs. They must be aware of the company's wrongdoing and not exceed the required remedy. Regular communications and written reports are essential to protect all parties involved. The UK government aimed to ensure that DPAs allowed corporations to deal with historical wrongdoing proactively and effectively. They introduced a tough requirement for companies to use an independent monitor to avoid prosecution. The government acknowledged the role monitors could play in ensuring corporations kept their promises during settlement negotiations. The UK DPA Code of Practice emphasized effective internal compliance and monitor oversight. The monitoring and compliance program in the UK is stipulated under paragraphs 7.11 to 7.22, which outline the appointment of a monitor, the role of the prosecutor, the court's discretion, the company's responsibilities, and the obligation of a monitor. The US Government Accountability Office published a report in 2009 on the use and oversight of deferred prosecution agreements. The report revealed challenges in monitoring compliance, including finding suitable candidates, determining monitors' job scope, and addressing conflicts between companies and monitors. It also highlighted the lack of clear communication between companies and appointed monitors, lack of leverage for addressing issues, and inadequate termination provisions. Monitoring and compliance in DPAs are crucial for ensuring companies comply with agreements and reform. Monitorships can provide government benefits, allow companies to prioritize ethical concerns, and provide focused supervision and training. They can reduce the risk of future misconduct by continuously reviewing policies and procedures, encouraging cooperation between companies and legal enforcement, creating a medium for whistleblowers to report misconduct, enhancing internal compliance, and promoting compliance among violating organizations. Overall, monitoring and compliance in DPAs drive positive changes in corporate behavior, enhance compliance, and ensure adherence to legal and ethical standards, ultimately safeguarding accountability and integrity within corporate entities. The monitoring and compliance in DPAs vary depending on the facts and circumstances. In some cases, the requirements for monitoring and compliance are more complex, while in others, monitorship is not required. For example, Saklat Limited was not obligated to hire an external monitor to supervise its adherence to the DPA, but was obligated to provide an annual report on its internal compliance evaluations. This decision may be influenced by new training programs, policy and procedures implemented by Saklat, which led to the discovery of misconduct. In the case of Airbus, in light of the continuing monitorship to be conducted by the French anti-corruption body, no independent compliance monitor imposed on Airbus under the agreement with the UK Serious Fraud Office and the US Department of Justice. The tone from the top and tone from the middle are crucial in deterring criminal activity. Businesses must maintain a robust internal governance system through transparent policies and procedures. If a company commits criminal misconduct and embarks on a DPA, a monitoring and compliance program can revitalize the compliance program and organizational structure, safeguarding corporate accountability and integrity. However, implementing DPAs faces challenges, and the government or prosecutor may consider mechanisms such as determining the ceiling price of monitorship, supervising the process, resolving disputes, and offering incentives to successful companies. Monitors should also maintain open communication with top management, strike a balance between independence and cooperation, and proactively address any concerns. That's all, and thank you for your attention.